Now, ladies and gentlemen, I come to the other aspect of the waqf, that is classification of the waqf or kinds of the waqf. In fact, uh, from the Islamic jurisprudence of the from the Islamic jurisprudence point of view, a waqf may be of two kinds: public waqf and private waqf. One of the waqf is called as public waqf, and another is called as private waqf. Now, what is let us see what is the public waqf. So, I was speaking that waqf are classified into two classes: uh, public waqf and the private waqf. What is the public waqf? Very simple. When property is dedicated as waqf and the object of the waqf is welfare of the general public. So when there is a dedication of the when there is a dedication of some property by any Muslim, by any person, and the object of and the dedication is made, the property is dedicated for the general welfare or for the welfare of the public at large, then such a dedication of the property by any person who is owner of the property is called as public work. For example, where the declaration is made by a owner that he dedicates his or her property, such and such property, for the uh, for the maintenance, for the upkeep and maintenance of, for example, or for the construction of a school, madrasa, college, road, hospital. Now you see that uh, these are the public utility services. Therefore, where the object of the waqf is for the benefit of the public at large, for the welfare of the public at large, for the advancement of the public at large. For example, the Waqif dedicates his property that income arising out of his property will be applied for the maintenance of the poor of a particular city, area, village, etc. etc. So means the object of the work or the purpose of the work is welfare of the public at large. In the same way, for example, if somebody dedicates his property, providing that income of the property dedicated as a work will be applied or will be spent for the construction of a school or madrasa. Now, school and madrasa, they are the public institution. Public at large may be the beneficiaries from the school, and therefore such work will be called as public work. Therefore, when somebody as a owner dedicates his or her property, providing that income arising from the corpus of the property will be applied for the benefit of public at large, and the object is named clearly, then such work will be called as public work. Therefore, public work refers to the work that is created for the welfare of the general public rather than for the benefit of a specific individual, family, or for a limited group. The public work must serve a public or collective benefit. may be religious, pious, or charitable. The property under public waqf considered in is considered inalienable and irrevocable, that is, property cannot be sold or transferred later on at any point of the time. In the case Nawab Mir Kanan Razak versus Waqf Board of Uttar Pradesh, AIR 2000, Supreme Court emphasized the distinction between the private and public waqf. It held that purpose of the public waqf is to benefit the public and should be administered in a manner that maximizes public welfare. The court also recognized the authority of the Waqf Board in the administration of the Waqf properties for public benefit. Likewise, in Fakhruddin versus Tajuddin 1932. In this case, waqf has been defined as one where the property, public waqf has been defined as one where the property is set apart permanently for charitable, religious, pious, or benefiting the public or a larger group of the public or section of the society. So, meaning thereby that where the beneficiaries under a waqf are public at large or general public, such waqf will be designated or will be recognized or will be called as public waqf. Basically the classification of the waqf is based on the nature of the beneficiaries or purpose of the waqf. If the purpose of the waqf is to extend the benefit, financial benefit to the public at large, it will be the public waqf. If the beneficiary under the waqf is individual or family, then such waqf will be called, such waqf will not be called as public waqf. There is another case, Dr. M.A. Beg versus State of Maharashtra, again 2000. In this case, Bombay High Court held the question of whether a waqf property could be used for the purpose other than that originally intended by the waqf. The court held that properties of public waqf should only be used for the charitable purposes specified by the waqf. Any deviation from these purposes would be the violation of the intention of the trustee, violation of the waqf, and therefore it is not permissible under the law. Now the next point arises. What is the private waqf? Because I have already explained the public waqf with the help of the example, and therefore now the next class of the waqf that is recognized under Muslim law is the private waqf. Private waqf are those waqf which are for the benefit of the private individual, including the settler's family relations. Such a waqf is termed as private waqf. It is also called as family waqf. It is also called as waqf-alal-aulad. So, the point must be further clarified that when someone dedicates his or her certain specific property permanently in perpetuity, dedication is made in perpetuity. And the purpose of the dedication is not to benefit the public at large, but to benefit or to extend the benefit from the property dedicated as a work only to the individual or specific person. An individual of the specific person may be the waqif himself, his family members, or his descendants, or generation to generation. So, where under a waqf, beneficiaries are the descendant of the waqif, generation to generation, then such a dedication, such type of the waqf is called as family waqf, private waqf, and popularly it is known as waqf-alal-aulad, meaning thereby that where the descendant of the waqif, generation to generation, until total extension of their line of descendant are beneficiaries they are, then such type of the waqf or such dedication will be called as waqf-alal-aulad, because in such dedication beneficiaries are aulad of the waqif, generation to generation, descendant of the waqif from one generation to another generation until there is a total extension of the, if this is the case, if this is the category of the beneficiaries under the waqf, then such type of the waqf is called as waqf-alal-aulad. Sometimes it is also called as the public waqf, private waqf, because sometimes the beneficiary under the waqf may be the waqif himself for his lifetime. So this will be a private waqf. Sometimes the beneficiaries under the waqf created by the waqif will be only the family members of the waqif, or some relations, selected relations of the waqif. Then such waqf will be called as the family waqf or private waqf, and where the beneficiaries under the waqf are the descendant of the waqif or generation to generation, such waqf is called as waqf-alal-aulad. For example, X, a Sunni Muslim, X is a Sunni Muslim, and he makes a declaration dedicating his property as waqf, providing that income from the property dedicated as a waqf will be applied only for the maintenance of the children of the waqif and their descendant from generation to generation, and at the same time he provides that in case at any point of the time there is a total extension of the, then it may be applied for any other purpose recognized by Muslim law as religious, pious, or charitable, then such waqf is called as waqf-alal-aulad. Or, ladies and gentlemen, here it must be clarified that Muslim law has given equal recognition to the public and private works. Both are the subject to the rules of divine property when the rights of the waqif are extinguished and it becomes the property of God. Both of these are created in perpetuity and property becomes inalienable. Like a public waqf, a private waqf can under no circumstance fail, and when the line of the descendants becomes extinct at any point of the time, the entire uh, uh, income of the property will be applied for any purpose recognized by Muslim as religious, pious, or charitable. And the waqf alal aulad according to the Muslim law, is as good and pious as waqf-alal khair or public waqf. In Abdul Sattar versus Adequate General in 1933, it was held that it is impossible to contemplate the property transferred to Almighty God subject to the condition enforceable in the temporal courts for recovering that property for the benefit of settler. However, the rule of irrevocability does not apply to the following conditions: waqif, reserving the power to alter the beneficiaries, add to their names, exclude some names, exchange mutawalli, change the procedure and rules modifying the instruction for its management. But court said that we can distinguish between an interviewers of the work and a testamentary work. Commands the approval of the Sharia law, um, that is approval of the holy prophet. Therefore, waqf-alal-aulad is as good as the public. Waqf-alal-aulad is falls under the category of the private waqf, but waqf-alal-aulad is duly recognized under Section 3 subclass R section 2nd of this Act. Uh, Here, friends, uh, before the passing of Waqf Act, because for the first time Waqf al-Awlad was given the statutory recognition under Musalman Waqf validating in 1930. And the Musalman Waqf validating in 1939 was passed basically in a specific background. I would like the audience to uh, take them in the background of passing of Salman Waqf validating Act 1930, because this was the first piece of legislation on the subject of the Waqf. Before that, there was no legislative, uh, there was no law enacted by the parliament or any legislative body on the subject of the Waqf. What happened? That before 1930, a case was decided known as Abdul Fatah Muhammad versus Rusundhar Chaudhary. Uh, in Abdul Fatah Muhammad versus Rusundhar Chaudhary, what happened that Waqif was a Samidar, and before leaving for Hajj pilgrims, he dedicated his certain properties as waqf, providing that income of the waqf properties dedicated as a waqf will be spent for his some family members, and thereafter it will be applied for their descendants generation to generation until the total extension of the family line of descent. And it further provided that in case there is a total extension of the line of descendants of the Waqif, then income of the property will be applied for the maintenance of the widows of a particular area or poor. The Waqif went to the Hajj pilgrims and thereafter he died. Then this Waqf was challenged on the ground that Waqf is a permanent dedication of any movable or immovable property by any person for any purpose recognized by Muslim law as religious, pious, and charity. Here the challenge was made on the ground that in waqf-alal-aulad, basically income is to be applied not for the welfare or benefit of the public at large. This is not a public charity, it is not meant for a public charity, rather it is meant for a family aggrandizement or for the maintenance and upkeep of the limited number of the family members, and application of the income of the work property for the maintenance and upkeep of the family members generation to generation cannot be considered as charity under Muslim law, and therefore such work will should be declared as white. Matter was heard by the three judges of Privy Council, which also included Sir Justice Amir Ali. The English judges basically they fail to understand the religious sanctity of this waqf-alal-aulad, and being influenced from the concept of the English charity, they held that in a dedication where the substantial portion of the income is dedicated to the family members generation to generation, and only a nominal income, they too in remote time, will be applicable to the general charity or for the poor. So here, how can one believe that a property which is dedicated only for the welfare and maintenance of the family members, how can it be a charity under the Muslim law? This is basically this is the family aggrandizement. This is the provision made for the family aggrandizement, and the element of the charity is very nominal, illusory. They too become applicable only in the remote chance when there is total extension of the family members. Only then the poor and the widows will be entitled to take the benefit out of the property dedicated. So where the court held that where the a chance of the charity is remote or illusory, how can such dedication be regarded as a waqf? And therefore the Privy Council in Abdul Fatah Muhammad versus Rusumdhar Chaudhary case declared waqf-alal-aulad as white. Ladies and gentlemen, Justice Amir Ali gave the dissenting opinion, and Justice Amir Ali, in support of his dissenting judgment, quoted various precepts providing or supporting to the concept of the waqf-alal-aulad. And Justice Amir Ali quoted on the basis of authority of the certain tradition that under Muslim law, charity begins at home. Means the court held that, of course, making the provision for the benefit of the poor, widows, or general public is a charity. But at the same time, making the provision for the maintenance of the family members is also a charity within the meaning of the saying of the Holy Prophet himself, where he is reported to have said that charity, giving something in charity to a stranger brings one reward, but doing the charity for his family members brings the double reward. And therefore held that under Muslim law, making the provision for the better future of the family members or his descendant is as good charity as making the provision for the welfare of the public at large. Rather, the making provision for the better future of the family members is more good charity than the charity for general public at large. And therefore Justice Mahmood, on the basis of the certain authority of the saying of the Holy Prophet, held that waqf-alal-aulad is as good waqf, is as much religious as the public waqf or waqf-alal-khair. And Justice Amir Ali held that there is no, under Muslim law, there is no difference between waqf-alal-aulad as well as waqf-alal-khair. So far as the religious sanctity is concerned, or religion, both are based on the verses of the Holy Quran as well as the saying of the Holy Prophet, because under Muslim law, charity for family members and charity for public at large both command the approval of the Holy Prophet, that is of the Islam. But justice, but English judges who were imbued with the concept of charity under because under English law, charity means welfare of the public at large, benefit to the public at large, to the general public, or for the benefit of a specific class of the society. For example, for the poor, downtrodden, underprivileged, widows, or resourceless person of class. If the beneficiaries under a dedication or under a charity are the public at large or a specific class of the society, only then such charity will be regarded as a charity, and dedication will be regarded as a charitable dedication. If it is for the welfare of the Waqif himself, his family members, his descendant generation to generation, means the specific property has been tied down in perpetuity for the welfare of the family members, for the aggrandizement of the family member, and where the dedication is intended for the aggrandizement of the family member, how can it be a charity? It is beyond the perception, legal perception, and therefore the court held in Abdul Fatah Muhammad Sundar Chowdhury that waqf-alal-aulad is not a waqf, it is a right. Therefore, there was a lot of the hue and cry, and on this judgment, and due to the public agitation, the then English government moved a resolution, a bill, and enacted Musalman Waqf Validating Act 1913, reviving the waqf-alal-aulad again. And therefore, friends, on the basis of the Musalman Waqf validating 1913. Till date, waqf-alal-aulad has been recognized as waqf, and it is also recognized as waqf under Section 3 subclass R second of the Waqf Act 1995 as amended in 2013. And therefore, according to this waqf-alal-aulad is a waqf within the meaning of the Act 1995 amended in 2013 to the extent to which the property is dedicated for any purpose recognized by Muslim law as pious, religious and charitable. In 2013, it was further amended and now it was clarified that in case the line of descendant fails, then income of the waqf will be applied for any purpose recognized by Muslim law as charitable, religious, for example, for the development, education, and for poor, etc., etc. So uh, it was revived and it is continued. Therefore, waqf-alal-aulad uh, is a waqf which is meant for the benefit of the children, descendants of the settler. Because under Muslim law, it is open to a Muslim to dedicate his properties for the maintenance of his own children and descendants from generation to generation, and such a dedication is one of the most pious and charitable object of the waqf. In no other system of the jurisprudence, the concept of the charity begins at home is more pronounced than in the Islamic legal system. The Holy Book repeatedly refers to the spending your substance for your kindred and hadith, which is one of the recognized source of Muslim law, is replete with the precept of the Holy Prophet declaring the dedication to the family and descendant as glorious act and pity. According to the messenger of the God, family benefaction is an essential element of the charity. The Holy Prophet has declared that a pious offering to one's own family is more pious than giving the alms to the beggar. The most excellent sadaqah is that which a man bestows upon his family. The apostle of and so uh, on this saying of the Holy Prophet, basically, waqf-alal-aulad, concept of the waqf-alal-aulad is based. But the Privy Council in Rusumdhar Chaudhary versus Abdul Fatah Muhammad case failed to appreciate the historical background or jurisprudential basis of the waqf-alal-aulad and held that waqf-alal-aulad is not a valid waqf. Uh, and the court held that we cannot believe that author of the Muhammadan law intended that under the cover of pretended dedication to Almighty God, owners of the property should be enabled to secure it for their own use, protect it forever from their own and their descendants, for their own and their descendants, creditors, and repeated uh, alienation in respect of which they have received the full consideration. In our opinion, then the deed before us cannot be sustained as valid waqf. In case of Bikani Miya versus Sukhlal, also the court declared the waqf-alal-aulad as invalid or void or dedication. Uh, Friends, the majority held that the court in both in Privy Council in Abdul Fatah Muhammad versus Rusumdar Chaudhary as well as Bikani Miya versus Suklal case held that opinion of learned judge was founded upon the text of an abstract character and upon the prejudice. Their lordship refused to accept the absolute and extravagant application of the abstract taken from the mouth of the Holy Prophet and held, if a man were to deliver a crore of rupees and provide 10 for the poor, that would be at once recognized as illusory. So, whatever might have been the law prior to the Musalman Waqf validating land, it is now statutorily declared that it shall be lawful for a person professing the Musalman faith to create a waqf which in all other aspects is in accordance with the provision of Musalman law for the following purposes: for the maintenance and support wholly or partially of family, children or descendant, and in this way waqf-alal-aulad was given the statutory recognition by enacting Musalman Waqf validating 1930. Now, ladies and gentlemen, waqf-alal-aulad is again under a change. The Waqf Bill 2024 proposes some amendment in Section 3 subclass or subclass 2 of the Waqf Act 1995, and waqf-alal-aulad is likely to be diluted because in the opinion of the lawmakers at present, waqf-alal-aulad in a way affect adversely the right of female members of the family, and therefore they have proposed that waqf-alal-aulad should not be recognized as part of the waqf. Bill is under discussion. Even today, it was to be taken up in the House of the People for debate and discussion. Now, in what way it goes will be decided by the time to come. But anyhow, till date, Waqf-al-Awlad is a valid form of the Waqf in view of Section 3 subclass R second of the Waqf Act 1995. uh, to the extent it is religious, pious, and charitable, and in case the object for which family members are the line of the descendant, if the fail or family fails or comes to an end, then income of the work will be applied for the purposes as mentioned in Section 3 subclass or subclass second of the Work Act 1995 as amended in 2013.